Thank you very much, JNU Academic, for organizing this discussion. And congratulations to Gautam for writing yet again this very significant and meticulously researched and I would say elegantly argued book, the latest addition to the ever-growing list of books that come from the house of Gautam Bhatia. So congratulations. In discussing this book, I'm not going to ask explicit questions that Gautam has to respond to, but I would raise some maybe broader points for discussion from some of the emerging out of some of the some very enticing conceptual frameworks that Gautam has offered in the book, and the approach of the book, which is, he says, different from his earlier book, that most of you are also very familiar with, The Transformative Constitutionalism, a Radical Biography, in 9 acts. I would feel that even when Gautam is saying that that approach is somewhat maybe redundant to the way in which he's looked at the Constitution in this book, there is a sense in which I can feel that there is still a kind of lingering presence of that book in the present book. And this comes from the way in which he still has that referent that he presented in that book of the transformative, where the transformative constitution is seen as transforming the relationship between state and citizens, and the way in which the state itself is not seen as the only locus of power, and society and community are also self-regulating, sustaining units of power, and the state in some ways has to deal with it, address this, but in a way that the state is guided through the conduit of the constitutional courts, through the imperative of elaborating the rights register in the constitution, questions of equality, freedom, privacy, work, etc. And the judgments that he's looked at in that book are what he calls contrapuntal canons, where each of these judgments is also a dissident judgment or a marginalized judgment in some ways. So there is, I would feel, even when he in this book is making the transformative one of the several frames, he says. That's not the single frame that one could use to look at the Constitution, but one among several. And so what is it that he's doing in this book? He is consciously, he is moving away from the transformative as the sole approach through which what he calls the iterations of judicial decision making could be placed, and he locates these decisions within what he calls the larger framework of the history, texts, etc. of the Constitution, to see how power is constituted, or power is immanent in the Constitution itself. And to look at the Constitution as a power map. And when we look at the Constitution as a power map, like all maps, the Constitution would also be, as a power map, an undulating map. No topology of a map is a flat topography. Topography is uneven and undulating, and I think the undulation that Gautam talks about in the constitutional text of even even power constituted in and through the Constitution is about the contestations around power that exist in the Constitution. And these contestations, he would say, are resolved in some ways in a direction when judgments are delivered through what he calls a centralizing drift. But this centralizing drift itself is a conscious decision that is arrived at by and through judgments. and there is always a potential of a different kind of judgment which is present in the constitutional text, but would, he says, vest a disproportionate adjudication burden on the judiciary to take recourse to those absences in the those opportunities in the constitution. And therefore there is, I'm assuming, that's what Gautam is saying, that the judiciary, rather than taking up this burden and the responsibility, is abandoning and abdicating those responsibilities to give decisions that are steer away from those dimensions of power that make power accountable and democratic. So the reciprocals that he identifies, decentralization of power, pluralism, power dispersal, etc., are somewhat diminished because of the lost opportunities that the judges perhaps do not take up. A second point, and this is an approach that Gautam wants us to take to. And this approach is presented as a kind of caution. Don't read the Constitution linearly. Don't read it as a bare document. Look for opportunities and spaces itself, so that that's where you understand what is it that is present in the Constitution that does not preclude the possibility of a different judgment, but that possibility, even when it exists in the Constitution, is not taken up. Now I would want to, and this is not exactly a question, but now I would want to hear, bring back the framework of the transformative, that has become part of the scholarship on transformative constitutionalism, largely by Karl Clare, Piers Langa, and Etienne Murinet, to not talk about how power requires, with transformative constitutionalism, a culture of justification, and explain why power is being exercised in a particular way, but a different kind of, or maybe another argument that Clare also gives, where such an adjudication would require a different legal culture. And a different legal culture would mean that there are ways in which habits of mind, etc., that Clare talks about, and I think Gautam talks about that when he mentions constitutional common sense, and constitutional common sense in terms of what is it that how would lawyers present a case and an argument before a judge and articulate something that would conform to maybe the sensibilities of the judges, and a lot would remain therefore unarticulated, because that's how a case needs to be presented. So that is perhaps one question I have. The second thing that I thought was important and significant to me in the book is the way in which Gautam looks at power as a contested terrain that is inherent in the way in which the Constitution itself is organized, which is different from the way in which others who have also looked at power have looked at the relationship between power and the Constitution as a struggle over power. And the struggle over power, for example, for Bakshi, it would be, Constitution would be an outcome of a prior and continuing struggles over power, and the way in which the Constitution would codify struggles over power, and this codification would exist in the Constitution in the form of the dominant practices of state power, or in a different way, even as Uday Bhatia would have a different formulation that Gautam also refers to and discusses in the book, where the transformation of the social gives unfettered powers to the state, and therefore the Indian Constitution is in some ways reflects the Hobbesian notion of sovereign power of the state. But what was interesting to me was more I'm wondering whether this is also something that Gautam is presenting in his work when he looks at the constitution and therefore the abandonment of the earlier abandonment, a partial abandonment maybe of the earlier transformative frame, where he looks at maybe following not Uday Bhatia but also in formulations by people like Giovanni Sartori, who would say the constitution is firstly and primarily foremost, it is the frame of government. So the purpose of the constitution is that first the constitution ought to enable the control of the government over the governed, and it is only the second obligation that the government controls itself and limits its powers limits its powers and the exercise of political power through the instrumentalities of the constitution. So I'm wondering whether it is the frame of the government and the idea that a Bill of Rights, etc., would be an aspirational constitution, policy making that is pushed through the constitution, puts a disproportionate burden on the state and taxes its capacities of the state, etc. So maybe I'm not sure, but does this argument lead to that kind of an argument? Another question around the one of the interesting formulations that Gautam has in his book is the way in which people figure in the constitution, and in his presentation he also mentioned how the people who are present at the inaugural moment and are mentioned in declaratory statements exit the constitution, and this is the phrase that he uses, exit the people, the silences in the Indian constitution. And this exit, he says that the way in which people are symbolically at the inaugural moment included, and then periodically through aggregations during election time, etc., does not give people the participation in the spheres of governance like lawmaking, etc., that would consolidate and entrench a role, a continuing role for the people. My interpretation of that argument, not necessarily in those words. And I'm thinking there is then another kind of scholarship which looks at the people and their relationship with the constitution differently. And I'm thinking about works that most of you are familiar with, people like Rohit Day and Ornit Shani, who talk about competing practices of constitution making, etc., and the way in which it wasn't just an elite consensus, but there were dispersed publics, etc. But there is another maybe approach where one may not want to look for the people in the constitution, but look at the way in which people look at the constitution. So Rohit Day, for example, has done that in the People's Constitution. But there are ways in which, in the experience of the way in which the constitution is implicated in politics and contemporary politics, we've seen it unfold in different ways. So if you remember the debates that happened in Parliament on the 75th, the discussions around the Parliament on the 75th anniversary of the Constitution, where the Defense Minister said that the Congress and the opposition is in the habit of displaying that the small red book of the Constitution. He said, the opposition, the Congress, pockets the Constitution, while the BJP keeps the Constitution in their hearts. So this distinction is maybe leads us to a conceptual direction where and also historical experiences with pocketbook constitutions, and an example that most of you would be familiar with, and something that Linda Colley talks about in her book when she talks about the pocketbook constitution of South Africa, the 1996 constitution, which was consciously produced and distributed in a form which was easy to insert in your pockets. And this pocketbook constitution was used by protesters against President Zuma's regime in 2017 and the protester used the constitution to conceal their faces. And Colley says that this act of concealing the face is ultimately identification with the constitution and an affirmation of the transformative potential of the constitution. This last point that I'm trying to make is again going back and again talking about the way in which the Constitution would perhaps continue to be a transformative text even when the people are not read into the Constitution. Using again the framework of Linda Colley where she says that transformations, the Constitution, particularly the written text of the Constitution, so that it can be available in tangible forms. The written text of the Constitution is a contagious political genre, and it is a stirring text, even though it is an imperfect text, right? So I would, and then she invokes Jefferson to say that the constitutions would require vigilant, watchful people who would rally around the Constitution. So maybe a different formulation of the people is perhaps I would want to flag as a provocation. Thank you so much.